So welcome everybody. We are so excited to have you in class today. What a fun class. So these classes we host every single week, and we bring in these amazing guest scholars and professors to teach us more about the Constitution and really get perspectives from all different angles and the history of the amendment, as well as the history of America. So today's special guest is Professor Kurt Lash. What an amazing speaker we have today to teach us all about the two religion clauses. We're going to dive deep into that First Amendment, look at those two clauses. But as we told you as we were leading up to class, Professor Lash is so brilliant that you could pretty much ask him and he's going to be able to handle it today. So no pressure, Professor Lash, none at all. Professor Lash has worked with the Constitution Center for a long time, and he has really kind of helped us understand how to teach these big constitutional questions and issues. One of our favorite tools at the center is the drafting table. I'm going to share that link with you in a second. And this was the great work Professor Lash has been working on around the Reconstruction amendments. So I will share that with you all in a minute. But without further ado, I'm going to turn it over to our two top scholars in class today, Jeffrey Rosen and Tom Donnelly. You guys take it from here. I'll start sharing some links. And Professor Lash, thank you so much for joining us today.
Wonderful. Thank you so much, Curry. Welcome, Tom, my dear colleague, and welcome, Professor Lash. We're so honored to have you and so excited to talk about the religion clauses. I need to thank you, Professor Lash, for having helped us create the drafting table on the Reconstruction amendments. As Curry said, you typed in with your own hands the original drafts of the Reconstruction debates so that we could put those early drafts online. And it's just an incredible service to America. So thank you so much for that. Let me just jump right in because we have so much to talk about. Curry, if you don't mind, I'd like to share the drafting table for the religion clauses. And can I do that myself?
You should have all the privileges you need now.
Thank you so much. Professor Lash, we're going to go to the interactive Constitution and start exploring, and we'll start with the First Amendment. And what I'm going to ask you about is, what did the framers have in mind when they talked about conscience, freedom of conscience being an unalienable right? It's so interesting when we look at the language of the Virginia Declaration of Rights and the New Hampshire Declaration of Rights, to see freedom of conscience being described as an unalienable right. And if we go to the drafting table here, look at this wonderful description from Virginia, that religion or the duty which we owe to our Creator can be directed only by reason and conviction, not by force or violence, and therefore all men are equally entitled to the free exercise of religion according to the dictates of conscience. And I'll just show one more. The New Hampshire draft talks about among the natural rights, some are in their very nature unalienable because no equivalent can be given for or received for them of this kind or the rights of conscience. Every individual has a natural and unalienable right to worship God according to the dictates of his own conscience and reason. What did the framers have in mind when they talked about the rights of conscience being natural and unalienable rights?
Well, of course, and again, first of all, thank you so much for inviting me. I love doing any kind of work or event with the National Constitution Center. Jeff, it's great to see you. And great to talk about this incredibly important and foundational concept of American liberty. I love that you just quoted from Virginia, because there's a particular Virginian who was very key to crafting the religious liberty provisions in their Constitution, and who ultimately crafted both portions of the Constitution and the Bill of Rights, James Madison. And even before the Virginia Constitution had its ultimately adopted religious freedom statutes, Madison declared in a very important public document that the religion of every man must be left to the conviction and conscience of every man. And it is the right of every man to exercise it as these may dictate. And then, in words that then become enshrined, it is a fundamental and undeniable truth that religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. And that statement is part of that idea that it's an unalienable right. You cannot give the government power to coerce us in terms of religion. No person has an authority to give that right away. It's something that they hold in themselves and must exercise voluntarily and freely. Madison and the initial generation, the founding generation, understood the importance of this liberty. They saw what happened when governments tried to control religion, both in England and in Europe, and the bloody violence that emerged out of the religious wars due to governments trying to control people's religious exercise. And they were convinced and committed that that would not happen through the drafting of the American Constitution or on constitutional soil. So their ideas and their commitment to this unalienable right of religious liberty ultimately finds its way into the text of the Constitution and into the text of the Bill of Rights. The original Constitution, Article 6, declares that no religious test shall ever be required as a qualification to any office or public trust under the United States. And the First Amendment declares that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, although that clause, the First Amendment, originally only bound the federal government, in 1868, the people adopted the 14th Amendment, which prohibits states from violating any of our fundamental rights. And according to the Supreme Court, those fundamental rights include our religious liberties as declared by the First Amendment. So today, due to this commitment of the founders, no government can force you to go to church or force you to accept any religious belief or punish you for peacefully telling others about your beliefs and encouraging them to share your beliefs.
Thank you. That was so powerfully stated, and what a great introduction to this crucial idea. Just so I understand it, and our friends do as well, is it right that the reason the framers thought that I couldn't alienate or surrender to you or to the government the power to control my beliefs is because I can't entirely control them myself? They're the product of my sense impressions operating on my powers of reason and deliberation. And as a creature of reason, I can't surrender those powers of reason to anyone else. Do I have natural rights theory correct in saying that?
Well, I think that's right. There's an understanding that one's religious beliefs and one's orientation towards the divine and towards the creator are things that must come voluntarily out of the soul. Anything that's coerced is going to give you outward signs of compliance, but no inward commitment of soul. And so it's valueless. It creates a society of liars and hypocrites to try and use government coercion. You'll never get the soul. That only happens through, as you said, your own response to your own learning and the own movements of your internal spirit.
You know, just this morning, as it happens, I was reading Milton's Areopagiticus, the wonderful defense of free speech. And it's so inspiring to hear him connect freedom of speech and freedom of belief, and to say precisely that no coerced belief could be worth coercing, because unless one accepts the truth of the divine or questions the truth of the divine based on one's own power of reason, then the belief wouldn't be acceptable to the divine itself. It has to come from our own powers of reason. It's so inspiring. Let me ask you, what were the paradigmatic controversies that inspired Madison to write those beautiful words, which he took in part from the Virginia Declaration of Rights? Tell us about his memorial and remonstrance against religious assessments. Why did he write it, and what did he say?
Madison's memorial and remonstrance is a very important document in the history of religious liberty in the United States. And so you're right to bring it up as relevant to understanding where the Constitution came from. Remember, the colonies and then the states existed even before the Constitution. The states existed just as independent government entities under the Articles of Confederation for about 13 years, between the time of the Revolution and the time of the adoption of the federal Constitution. And during that time, states were passing their own constitutions and creating their own governmental institutions after the Revolutionary period, and they broke from British control. Virginia was struggling with the idea of how much liberty or what kind of religious liberty would be allowed in the state, and struggling with whether or not religious belief was so important to the functioning of democratic government that people should be forced to either adopt religious beliefs or at the very least support financially the existence of a state church. And Virginia had gone back and forth. They had required people to tax to pay taxes in support of the local church. It had fallen away, and now Virginia was thinking, this is even before the Constitution, Virginia was thinking of once again instituting coerced taxation support of local ministers and local churches. And Madison and Thomas Jefferson both objected to that. They believed, once again, that this idea of the conscience was inalienable, that one's religious beliefs had to be voluntary and not coerced. And so Madison wrote his Memorial and Remonstrance as sort of a political document, trying to encourage the people of Virginia to reject this idea, to reinstate an establishment of religion, a taxation establishment supporting a particular church. And in that Memorial and Remonstrance, he makes many of the arguments that we've already talked about so far, how conscience is, and the rights of conscience and the beliefs in one's creator cannot be given over to the government to control. That's the inalienable part of one's religious beliefs. Also the idea that those beliefs would produce nothing but hypocrites and liars, and in fact would ultimately lead to a weakening of people's religious belief, because it would now depend upon government support as opposed to people's internal and voluntary commitment and financial support. He succeeded, in fact. Jefferson and Madison succeeded in stopping the reinstatement of religious taxes. And in celebration of that, Jefferson goes forward and passes the bill for the establishment, not of religion, but the establishment of religious freedom. It declared this inalienable rights of conscience, and it was one of, I think, the three documents that Jefferson, three activities in his life that Jefferson was most proud of. This became the immediate historical background to the passage of the Constitution and the Bill of Rights. It's sometimes called the Virginia experience, because what was happening in Virginia was so important, because Madison was a framer of the Constitution. And most scholars believe that these ideas of the inalienability of the religious conscience made their way into the drafting of the Constitution and the no religious test of Article 6, and ultimately the First Amendment itself.
Wow, that is so inspiring. And friends who are watching, just to make sure we all understand what Professor Lash is telling us, when we talk about a right being unalienable or inalienable, those two phrases mean the same thing, we mean that when we're moving from the state of nature to form a government, we can't alienate or surrender to the government certain inherent rights because there's nothing we can receive in exchange for that surrender. They're inherent to who we are, and that's what unalienable means. I have so many questions. I know Tom Donnelly does too. I'm just going to ask one or two more, and then I'm going to turn it over to Tom. Jefferson had a very powerful vision of freedom of speech and freedom of conscience and freedom of religion. He was more of a strict separationist. In other words, he thought that church and state should be separated more than some of the other framers. But what were the core ideas of that Declaration of Religious Freedom that Jefferson wrote?
The core idea of the bill for the establishment of religious freedom was voluntary support of religion, and basically reflecting provisions that become a part of the Virginia Declaration of Rights, that a religious activity cannot be coerced by the government. Now, Jefferson had more ideas than just those that were in the bill for the establishment of religious freedom. Many of the founders believed that there could be some degree of cooperation and some degree of cross support between church and state, and that maybe government could participate in legislative prayers, or maybe it could generally support and encourage people to go to church. I think George Washington was one of the founders who believed that there could be general support for religious activity. I think the same thing's true for John Adams. Thomas Jefferson, however, was deeply suspicious of any government involvement in religion whatsoever, even so far as to believing it would be wrong to issue a Thanksgiving prayer once a year. He believed that it was simply ultimately corrupting of society and religion itself for government to have anything to do with religion, and religion to have anything to do with government. And of course, ultimately, he puts those ideas into the famous letter to the Danbury Baptist Association, in which he celebrates the complete separation of church and state. And we often associate the religious freedom provisions of the First Amendment with that idea of separation of church and state. But I'd be careful, and I'd encourage students to further investigate the different ideas that were in play at the time of the founding. Jefferson was actually a little concerned about religion and its possible role in society. He suspected that revelational religion, people who believed in the miracles of the Bible, were people who perhaps shouldn't be participating in political activity. And so he encouraged Virginia to ban the clergy from the Virginia legislature. James Madison was not so separationist. He truly was an egalitarian. Madison, although he shared some beliefs with Thomas Jefferson in terms of church and state, he believed that religion could be valuable and at the very least should be part of the equal share of ideas and beliefs that are brought into the public square.
So interesting. Friends, did you hear what Professor Lash said, that Jefferson and Madison disagreed about the relation between church and state, with Jefferson being a strict separationist and wanting church to have nothing to do with state and state nothing to do with church, and Madison being more in favor of equal treatment among sects and willing to tolerate some religious expression in the public square. It's also so fascinating to read about the theology of Jefferson, and there's a Jefferson Bible where he went through the New Testament and actually expunged everything that he considered to be monkish superstition or miracles of any kind, and left the ethics, which he thought was the core of the Bible, whereas of course Madison was a more less unconventional believer, and many of the framers had different visions of belief. One more question. And it has to do with the Establishment Clause. Tom Donnelly and I had the great pleasure of studying in law school with Akil Amar, our mutual friend, Kurt. And Akil Amar taught me a phrase that I hadn't learned since I studied for the SATs in high school, which I know some of our friends will be doing soon as well. And that was anti-disestablishmentarianism. And you know where I'm going here. Akil Amar's idea was that the central idea of the Establishment Clause was to prevent the federal government from disestablishing the state churches that existed in some states, like Congregationalism in Connecticut or Unitarianism in Massachusetts and so forth. So in other words, the states had established churches and you had to pay tithes to them. And the original point of the Establishment Clause was to prevent Congress from establishing a federal or national church, but to leave undisturbed those state establishments and to not allow them to be disestablished. Does Akil Amar have that history right or not? And tell us more about that.
A wonderful question and a wonderful issue for studying the American Constitution and how the American Constitution has changed over time. I briefly mentioned a moment ago that the original Bill of Rights bound only the federal government. For the first 70 years, the American Constitution, it was only the federal government that could not establish religion. It was only the federal government that could not abridge your freedom of assembly and speech, or your right to bear arms, or any of the rights that are listed in the Bill of Rights. That bill bound only this new and untested national government. And it left the states free, the state legislatures free to do whatever they thought was best in these particular areas. And it reflected an idea that liberty was best preserved and best facilitated by leaving certain important issues under the control of local officials, people who we know, people who we trust, people who we can hold accountable. And at the time of the Constitution, those people most trusted with these sensitive topics of fundamental liberties were state legislators. And so what Professor Amar has argued, and I agree with him about this, the original First Amendment's Establishment Clause was meant not only to prevent a national establishment, it was also meant to prevent the federal government from interfering with state regulation of religion. Let us decide for ourselves, the states said, whether or not to establish religion, whether or not to tax in support of churches. And in fact, that's exactly what happened during those first 70 years. The federal government didn't interfere with state establishments, and it didn't establish any religion itself. And states went different ways. Virginia went in the direction of disestablishment. Massachusetts continued taxation and religious establishments up until about 1830. Different states did different things. So what happened? When did states have to comply with the restrictions of the Establishment Clause? Well, again, I just briefly mentioned something happened in 1868. when we adopted the 14th Amendment to the Constitution, which declares that no state shall make or enforce any law abridging the privileges or immunities of citizens of the United States. The question has become, what were those privileges or immunities that states could no longer violate? And most people who study the 14th Amendment suggest that the reason why they adopted it after the Civil War came out of the experience of the suppression of rights and liberties in the slaveholding states. And so not only did we have to abandon and abolish slavery as this horrific violation of human rights, there also was a new sense in the country that states needed to protect other rights, not just general freedom and not enslaving people, but they had to provide certain particular rights that had come to be viewed as essential to being an American citizen. And in those southern states, for decades, they had suppressed speech. They had especially controlled Black religion exercise in the southern states. You could not, free Blacks often could not enter, whether preachers or not, couldn't enter the South. The slaves themselves were forbidden to be taught how to read the Bible. No Black religious assembly could meet without oversight and control by a white person or a white slave owner. There was enormous control of the practice and content of religion in the South. It was one of the most severe religious establishments ever erected on American soil. And so what I have argued is that by the time of the Civil War and the adoption of the 14th Amendment, people not only believed in freedom of speech on a state level and that religious speech could not be abridged by states, but they also believed that it had been wrong for states to establish religion and try to control the content and the methods of exercising one's religious beliefs. And so the Privileges or Immunities Clause of the 14th Amendment incorporates all of those rights listed in the Bill of Rights and now makes them applicable against the states. Free exercise, non-establishment of religion, freedom of speech and press and assembly. These are all rights from the Bill of Rights that have been incorporated into the 14th Amendment and applied against the states. My disagreement with Professor Amar, who's a friend and a mentor and someone who I just will always look up to as an extraordinary scholar, is Akil isn't sure that the Establishment Clause became something that should be applied against the states. Mm-hmm. It is because of my study of the suppression of slave religion and state control of religion that has convinced me that the country had come to the conclusion that non-establishment was now a national right that states needed to respect. But the conversation goes on.
Wow, that is such an extraordinary answer. Friends, I know that this is a lot of complex material to absorb, but it's very, and this is sort of, this is the advanced extra credit version for constitutional law, because these are cutting edge questions that Professor Amar and Professor Lash disagree about. But just to sum up, the only area of disagreement that he talked about, he said that at the time of the framing, there was agreement that the purpose of the Establishment Clause was to prevent the federal government from disestablishing state religions. After the Civil War, the Privileges or Immunities Clause incorporated or adopted most of the provisions of the Bill of Rights, so the states as well as Congress couldn't abridge them. And the only disagreement between these two great scholars, Professor Amar thinks that because the Establishment Clause was essentially a federalism protection, it was designed to protect states' rights, it didn't make sense to apply or incorporate it against the states. Whereas Professor Lash's scholarship found that the concern over the suppression of the religion of enslaved people was such a grave and urgent concern for the framers of the 14th Amendment that he thinks that that prohibition did mean to incorporate. All right, I must turn the things over to Tom Donnelly, who is also a great scholar of Reconstruction and the 14th Amendment. Tom, there's so much to, I know that you have to ask Professor Lash, but why don't you take it from here and ask him whatever you'd like about maybe picking up on this question of the experience of enslaved people having their religion violated during Reconstruction and how that affected the views of the framers of the 14th Amendment when they drafted it.
Well, thanks so much, Jeff. And I don't want to monopolize too much with my questions because we also want to bring in the chat. But yeah, I would love to hear a bit more, Professor Lash, because you're the leading scholar of the text and history of the 14th Amendment. Just a bit more about the ways in which the people who pushed for the 14th Amendment were informed by the experience of African-American churches, and furthermore, how central the African-American church was to the push for constitutional reform during Reconstruction and thereafter. So the degree to which religious liberty is absolutely essential to, building a more perfect union and a more perfect constitution.
Absolutely. Thank you for that question. Yeah, the commitment of Black civil rights advocates, both North and South, both escaped slaves and slave religious assemblies, and then after the Civil War, the Freedmen's Conventions all played an enormous and important role in driving this new understanding of national liberty. Now here I want to back up just a little bit for students, because we're talking about pretty intense historical ideas. But I think the simplest way to think about it is that when we first got the American Constitution, we weren't sure whether or not we trusted the federal government with a lot of power. Okay. And so we only gave it certain enumerated powers. States could regulate anything, where you parked your horse, or what kind of zoning or torts, or education, religion, speech, anything. The federal government, we weren't sure about. This was a new idea, a new experiment. And so the federal government only had certain powers. Everything else was left to the states. And sometimes you'll hear people talk about the 10th Amendment and how the 10th Amendment represents all powers not given to the federal government or reserved to the states. That's federalism. Federalism is this balance of power between the federal government and the states. And that really was the big idea at the time of the founding. But then we went through this period of struggle, a struggle that increasingly surrounded debates over slavery, as slavery became more and more entrenched in the South, and as abolition became more and more predominant in the North, with people claiming that slavery was unacceptable. It was a covenant with death. It was an unacceptable violation of human rights, and it was against the will of God. So you have Northern abolitionists calling for the end of slavery. You have, on the other hand, Southern slave owners who are getting stricter and stricter in their control of the lives of the enslaved people in the South. These two aspects of the country increasingly battled one another, and it got to the point where slave owners in the South were trying to control speech in the North. They were demanding that Northern abolitionists stop talking about slavery, stop putting their materials in the National Mail, stop petitioning Congress to abolish slavery in the District of Columbia. They stopped allowing people to travel freely throughout the South. More and more, state treatment of slavery was affecting everyone's rights throughout the country, not just the slaves themselves, but also white objectors to slavery. And so an idea grew in the North that liberty could not simply be left to every state, that was not good enough, that for us to really flourish as a country, there had to be certain rights that every state should respect. And they believed that those rights included the rights to freedom, slavery should be abolished, but also rights of religion, and also the rights of the free exercise of religion and non-establishment of religion. This was a new national idea, not a federal divided power idea. It was everyone in the country should have this right no matter where they go. That national perspective became enshrined in three critical amendments passed right after the Civil War. The 13th Amendment, which abolished slavery anywhere in the nation. The 14th Amendment, which gave national rights of citizenship and rights of due process and equal protection to everyone throughout the nation and told states they had to respect those rights. And the 15th Amendment, which prohibited states from denying the right to vote on the basis of race. These were new national conceptions of freedom. No longer did the country feel comfortable leaving these decisions to local state assemblies. We now understood the importance and the good that can come from national protection and the protection of these rights at a national level. It was a change in who we were as a people. We were no longer suspicious of federal power. Now we had federal power that had furthered the Union Army and saved the Union. And now we're giving us national rights. It was a new idea, and it's part of what made us the country we are today, right there in the 1860s.
Absolutely. It's why, so many scholars refer to that period as America's second founding, this idea of a new constitution, a rebalancing of the constitutional system. At this point, Curry, I don't know if there must be some great questions in the queue. Maybe we could bring in some of the outside questions and see what's on everyone's mind.
First of all, the students are loving this discussion and have already asked that the next exhibit at the National Constitution Center look at freedom of religion and speech through the lens of the African American churches and the Reconstruction exhibit. So just for your next project.
I would like to intervene just real quick, because again, I didn't want to monopolize too much time. As we got this national idea, this idea of national liberty was driven by civil rights advocates like Frederick Douglass, who the escaped slave, who became the incredible statesman and abolitionist in the North. He was demanding national liberties and national freedom and national political rights for Blacks. At the same time, the Freedmen Conventions in the South, all during the 1860s, were talking about their right now to assemble religiously and develop their own beliefs free from government discrimination and harassment. And that became incredibly important, not only so that they could finally be free to exercise their religious beliefs, but those African American churches in the South became the centers of political mobilization. For the first time, they could meet as a congregation and as a community and not only talk about their beliefs and their duties to God, but also their beliefs and their duties to each other, which translated into the need for more political power. So religious freedom was incredibly important to the freedmen in the South, and their religious liberty was part of their slowly aggregation of political liberty.
Our students, and we'll gather this afterwards, but they're all saying, I didn't know this. I didn't know this, which is why Vicki suggested an exhibit on it. Thank you, Vicki, great idea. But any kind of tools or resources we should guide them to. I did put in the chat that your next edition of series is coming out in spring 2021 of a books on Reconstruction. And I'm sure we'll be doing programming with you around that. But anything else we think of, students, will send your way. One question that I wanted to kind of wrap up with is Lainey's question. Now, Lainey was looking at the First Amendment and said, why do they put speech and religion in the same amendment? If these are such kind of key big moments and key big ideas in the Constitution, why did they put them into one?
Why do they put both speech and religion in the same?
Into one amendment and not separate them out?
That's a wonderful question, and it takes me back to my mentor Akhil Amar, who you really should have on as often as you.
Oh, he's coming in a month.
Well, okay, then you continue this conversation with him. But one of the things that he taught me, and one of the things that he's written about, is that to talk about freedom of speech without talking about religious freedom is to put on the play of Hamlet without including the prince. In other words, there is no freedom of speech without the role of religious speakers who drove that particular idea. At the time of the founding, and I think it's been true to this day, the people who have been most vocal about their beliefs, the most insistent in putting their ideas on paper and circulating their ideas among the public, have been religious believers who believe that the community is called before the judgment of God to believe and respect the requirements of God in terms of freedom and human rights. And so freedom of speech was part of religious exercise. If you look at the 10 commandments, you have commandments that relate to your duties to God in a vertical sense, but you also have commandments about how to treat your neighbor, the horizontal aspect of one's duties to the Creator. And that aspect of taking these ideas and demanding that society provide civil rights and basic rights the Creator has given all people has always been part of speech. It's that religious aspect and that religious exercise. And of course, for me growing up, that was most represented in the activities and the speeches of the Reverend Dr. Martin Luther King, who grounded his calls for equality and fair treatment of Black Americans in his beliefs about God and in our common understandings of the duties that we have all being created equal by our Creator. His speech and his political speech was religious speech. His activities in the public were religious activities. They're intertwined, and it makes perfect sense that they're right next to each other in the First Amendment.
Awesome. Okay, I'm going to sneak in one more question because I can't help myself, because Barbara brings us all the way to current day. Same question in a way, but why did the government have the power to force churches to close last year during this time, if power of speech and religion is so important. And we were thinking about the students all week were asking about the case in California, the Supreme Court looking at the governor's order to fully close churches. So this isn't something just 230 years ago, 260 years ago. This is debates we're having this week in the Constitution.
It is something that has been on my mind. It's been on all of our minds, both as religious believers and citizens and people trying to respond to the pandemic, and certainly on the mind of constitutional scholars and people who work on the First Amendment, because there is this clash between the government's attempt to try and get the pandemic under control, and that has led to closures and restrictions, not only restrictions on meeting, how many people can meet. Sometimes California shut down assemblies altogether and banned singing and chanting, such an essential aspect of so many different religions. That's been the government's effort to try and protect the public. But in protecting the public, have they disvalued or undervalued the essential aspect and the essential role that religion plays in the lives of so many people? And isn't that value represented in the First Amendment? And doesn't it protect us from this type of total suppression of religious exercise? What you'll find, and I think the students suspect this or wondering how it actually plays out, but in any dispute over constitutional rights, there's always a point at which that right must stop due to some type of countervailing or compelling interest. The right, and the standard way of saying it is you have the right to swing your arm, but not to the point of hitting somebody else in the nose. That's a simple way of thinking about it, but I think it's an effective way. What the government has argued is that religious exercise during a time of pandemic is simply too dangerous. It risks punching other people in the nose with a virus, I guess, if I'm going to use that particular analogy. But what religious adherents have argued is that you have not investigated and you have not carefully gone about exploring other options to respond to the pandemic that do not require completely shutting down churches. And thus, it's all been moved into the courts as courts try to determine whether or not the government has justified its shutting down of churches and singing and assemblies, or whether or not religious believers are correct. The government has been more restrictive than is necessary. And when it comes to a fundamental constitutional right, the government bears the burden of explaining why whatever it's doing is absolutely necessary. And in some cases, the government has not met its burden. And that's why last week, the Supreme Court invalidated the total ban of in-person religious assemblies in the state of California.
Fascinating. And so many, that swinging arm, that is fantastic. I hope all the students remember that you can swing your arm, but you can't swing your arm so much to smack somebody in the face. I think you've given us so many great ideas and understandings of how to look at the First Amendment, how to look at it through time in history, and through the power of the African-American churches to make change before and after the Reconstruction Amendments into the Civil War, and how much speech and religion are intertwined. The big kind of key takeaway that I just want to amplify and say again is you said the best thing. You said, you have great scholars like you and Akhil Omar, and sometimes you agree, sometimes you disagree. And then you said, and what I wrote in the chat was like, they're doing it civilly. They're doing it in a healthy way. And what you said was awesome. And one of our students says, I want that. I want to like that. I want to put it on a t-shirt. Your line was, the conversation goes on. What a great way to keep the dialogue moving and open and healthy. So thank you so much for so many great gems today. I'm going to turn it back to Tom and to Jeff for what a wonderful Friday class.
Absolutely. Curry, I'll just, Professor Lash, I'll just echo Curry's warm thanks. I know I speak for Tom as well. You have inspired all of us by providing a model for the central virtue of reason informing our beliefs. Unless we test our beliefs in civil conversations like the one we're having now, then we can't be confident of the ultimate power of truth. And that's why the framers thought that freedom of conscience was the first of our unalienable rights, the very core of our freedom, this freedom of thought and belief, and this power to speak and express our beliefs. And you've helped us understand that with great power and light. On behalf of all of us at the Constitution Center, thank you, friends. Have a wonderful weekend and keep this conversation going in your own minds by learning more, by reading those early drafts of the Constitution that Professor Lash helped us put online, by reading some of the secondary works that we talked about, like Professor Lash's work and that of Akhil Amar, and always testing your own ideas with conversation and your own powers of reason. Thanks so much. Have a great weekend all.
Thank you so much. It's been a pleasure.
It's wonderful to talk. Hope to have you back soon. Thanks. Have a good weekend, everybody.